to all of you on behalf of Parul Institute of Law, Parul University. I am Professor Dr. Debaruti Haldar and I have with me Dr. Wendy O'Brien. Dr. Wendy O'Brien is Crime Prevention and Crime Justice Officer with UNODC headquarters in Vienna. She develops and implements legal advisory services and capability building projects in the fields of police reform, victim support, and access to justice in her capacity as Officer for Crime Prevention and Criminal Justice, Department for UNODC. Dr. O'Brien is highly experienced academic and legal researcher, and she has served more than 11 years in academic roles in Australia. Prior to commencing with UNODC in 2018, she was criminology convener for Deakin University, where she currently holds the position of adjunct associate professor. Dr. O'Brien is also the visiting faculty with the United Nations Interregional Crime and Justice Research Institute, where she teaches in the LLM on transnational crime and justice. Dr. O'Brien's academic research comprises legal scholarship and public policy research, including the evaluation of justice and social sector services. She has published widely in leading international journals on topics of violence prevention and criminal law reform. Her co-edited book, Violence Against Children in the Criminal Justice System, was published by Routledge in 2020. Dr. O'Brien has regularly been invited to serve on research advisory boards for violence prevention projects and to provide expert evidence to national and state inquiries on law and policy in the fields of violence prevention and access to justice. From 2007 to 2014, Dr. O'Brien worked in criminal intelligence at the national level. As senior specialist with Australian Crime Commission, she led a program of intelligence-led research and provided legal and policy advice on access to justice, sexual violence, and the well-being of children. Dr. O'Brien holds a PhD in Gender Studies, a Master of Public International Law, and a Master of Evaluation. I welcome you, Dr. Wendy O'Brien, on behalf of Parul Institute of Law, and we have with us our Honorable Director and Dean, Dr. Akil Syed, Professor Dr. Akil Syed sir. I request Dr. Akil Syed sir to kindly welcome Dr. Wendy O'Brien.
A very good morning, ma'am. Here we are in an afternoon, so I offer you a namaste, our Indian way of greeting the guest, ma'am. It's my great pleasure that your good self has spared your valuable time and be here at the Faculty of Law, Parul University. Though it's a virtual platform, we wish that whenever you make your visit to India, please do visit to our university also. At the same time, I'm also thankful to Professor Debaruti Haldar, who has kindly arranged this expert session. Though I am today out of office, but especially I managed to be here on this particular webinar that I would definitely attend and listen, Professor Wendy. And it's, ma'am, it's not only one occasion. Rather, we want to get associated with your good self and your organization, ma'am. So this is our small step towards your organization and towards your good self. Ma'am, ours is a private university established as per the State University Private University Act 2015, and the Faculty of Law also has UG as well as PG program. And as Professor Debaruti would have definitely mentioned you, that we do have a variety of all this research program also in research centers, where we do perform the research related to forensic science, because basically I'm a man of physics. So we have developed the forensic physics and interdisciplinary study and forensic law. Of course, criminology, which is the specialization of my colleague, Dr. Debaruti. So we do have a Center for Criminal Study and Criminal Law. Similarly, we do have Center for Gender Justice, Center for Juvenile Justice. So, ma'am, on each of these front, we would like to get collaborated with your good self, and we request you to kindly extend your support for all this activity. We would be highly obliged, and it will be our great pleasure, ma'am, to host you at the Parul University in India. Today, I will not take much time because we all are eager to listen your good self. So I take your leave once again, welcome you, and thank you for sparing your valuable time, ma'am. Please.
Dr. Wendy O'Brien, so the platform is yours, and I welcome all to hear a very erudite and also very thought-provoking lecture of Dr. Wendy O'Brien on human rights and criminal law reform. Dr. Wendy O'Brien.
Thank you very much indeed. I hope that you can hear me well. Good, thank you. It's indeed my pleasure and honour to deliver this lecture today, and particularly as this is timed so closely to United Nations Day. And I'd like to extend my sincere thanks for the kind invitation to Professor Dr. Akhil Saeed, and thank you for your warm remarks of welcome just now. And thank you also, Professor Dr. Debrati Halder, for the invitation. So before commencing, I would also like to thank the participants for our lecture today, and extend my thanks to you for your interest in the United Nations, the rule of law, and in our shared efforts globally to uphold human rights. So I work at the United Nations Office on Drugs and Crime at our headquarters in Vienna, and I am based in the Justice section, which is a team that focuses on a large range of thematic issues that are related to crime prevention and criminal justice. And I'll talk about that our criminal justice systems are not calibrated correctly, or when there are discriminatory laws that mean that victims are criminalized, when they seek access to justice, when they seek legal protection. So discriminatory or deficient law and procedure, sometimes undue delays within our criminal justice system that mean that there really is no recourse to justice at all, because it simply takes too long and the trauma and the suffering is too deep through that period of delay. But then we can also see the opposite problem, which is that responses are overly expedient. There is no attention to the detail, to the circumstances of the crime or the victimization, and an overly expedient response can indeed result in human rights violations. And there can also be an over-reliance on punitive responses. So sometimes we see tough on crime responses at the political level, and these flow into law reforms that then can mean that there are very punitive sanctions that don't, in fact, adequately deliver justice to victims, and don't place an emphasis, for example, on rehabilitation of offenders so that we can prevent that cycle of recidivism and reoffending. And there are also, there's also harmful norms and stereotypes that influence the development of law, policy, and practice, and these need our attention as well. So at UNODC, our work is guided by the international legal framework, which includes, of course, both binding international treaties, International Covenant on Civil and Political Rights, the International Covenant on Social and Economic Rights, and also the conventions that enshrine the rights for specific groups. So, for example, the Convention on all forms of Convention on the Elimination of All Forms of Discrimination Against Women, or the Convention on the Rights of the Child, Convention on the Elimination of Racial Discrimination, for example. And of course, when we talk about this legal framework, it's important that we also think about the United Nations standards and norms in crime prevention and criminal justice. And these are an internationally agreed authoritative set of guidelines and minimum standards and best practices for effective and fair criminal justice structures. And these are drafted by member states in agreement. And there are more than 58 different instruments of this kind, covering issues such as non-custodial sanctions, justice for children, crime prevention, violence against women, protection of victims, and so on. So these standards and norms, which are administered by UNODC, but not drafted by us, it's important to note that they are drafted globally by a process that is multilateral. But we administer those, and it is largely our job to promote their use globally. So we work in partnership with member states when member states invite us to do so, to help strengthen criminal justice systems so that they are in line with this set of standards and norms in crime prevention and criminal justice, which are, of course, a part of that broader international legal framework. So examples of these, for example, are the Nelson Mandela rules, which provides minimum standards for the treatment of prisoners, or the Bangkok rules, which provides minimum standards for the treatment of women prisoners. And we might also think, for example, about the Beijing rules, which provides minimum standards for the administration of juvenile justice. So our work is using these standards and norms to support member states to bring their practice into closer alignment with the international legal framework. So this is inherently human rights work that we are undertaking. So to bring this to life a little and to focus in further detail, perhaps we could consider some scenarios. Imagine, if you will, that a domestic violence helpline suddenly records a 5-fold increase in calls from women experiencing abuse in the home. The helpline cannot cope, and many calls go unanswered. Imagine another scenario in which an overcrowded prison wing experiences a sudden outbreak of illness. The prison infirmary is overwhelmed, disease spreads rapidly throughout the entire prison population. And, if you will, a third scenario to imagine: a child suddenly loses their meagre income. This is a child that has no access to school, and now they have no prospect of another job. The child is evicted from her street shelter, and she has nowhere to go. So I have raised these scenarios not because they are speculative abstractions, but because, of course, we know that these are concrete examples of the acute justice needs that individuals experience daily around the world. These are concrete examples of the challenges in delivering equal access to justice for all. And we have seen, of course, that these scenarios and many more have played out in the context of the COVID-19 pandemic. So it's not to say that they are new scenarios, but indeed that some of these risks have deepened during the pandemic. So if we take the first scenario as an example, we'll just return to this one. We can say that we know that there are alarmingly high rates of gender-based violence around the world, and these persist globally despite efforts to reduce these numbers. But we also know that these numbers have worsened during the COVID pandemic. And it is indeed the case that in some countries, calls to helplines have increased fivefold. And we also recognise that in many places, women and girls don't even have access to these basic services of a helpline that they could call. So the figures that are recorded, let's imagine a fivefold increase. This does not provide the full picture. There is indeed, if we speak about this in criminological terms, there is indeed that dark figure of crime, those crimes that don't go reported. There are in many countries, there is no access to justice for women experiencing abuse because indeed they are unable to report crimes against the person unless they have the presence of a male guardian, and it may indeed be the male guardian that is the perpetrator of the violence. So you can understand the way in which that pathway to justice is fully closed in that situation. But if we think about the situation in terms of COVID, we know that in many parts of the world, domestic violence centres and shelters have closed because of lockdown restrictions. We know that social workers and trauma counsellors and lawyers have lost face-to-face contact with their clients, and women and girls fear leaving their homes due to the restrictions of lockdown, because in many places, of course, law enforcement are enforcing those lockdown measures. So women and girls already facing risks of violence now face increased barriers to accessing justice. And another important consideration here is that police resources may be diverted because of the pandemic, and court access is delayed due to court closures and so on. So these acute challenges that have been further brought to light during the pandemic, but of course long preceded the pandemic, indicate what is a long-standing global crisis of gender-based violence. And this is to the extent that the United Nations Secretary General has declared COVID-19 has further exposed violence against women as a global emergency that requires urgent action. So, this is indeed a critical juncture, I think, for us globally, and it's incumbent on us to ensure that the COVID-19 crisis is not the catalyst for a deepening of the inequalities in access to justice. And of course, the longer the pandemic goes on, I think the deeper this risk is. And I think that while it's clear that eliminating gender-based violence requires coordinated and well-resourced multi-sectoral approaches, I'd like to focus on the role of the criminal justice system as having a particularly important role to play. And this, I think, is because I would like to steer our reflections towards discrimination and towards structural violence within the context of this presentation. So as noted by the Committee on the Elimination of All Forms of Discrimination Against Women, gender stereotypes, stigma, harmful and patriarchal cultural norms, and gender-based violence adversely impact on the ability of women and girls to gain access to justice on an equal basis with men. So the scenario outlined during the pandemic of increased calls to helpline and court closures and so on deepens the challenges for women that are seeking justice. But it is a reminder that in any case, pandemic or not, it's important for us to recognise and dismantle the entrenched patterns of inequality and discrimination that pervade criminal justice processes. They pervade our societies more broadly, but they also pervade criminal justice processes. And this, I think, is the focus of our discussion today. And I'd also like to say that while I'm not speaking about this in detail in this presentation, when I'm speaking about gender-based discrimination and sex-based discrimination, I would also like to be clear that I'm including gender and sex-based discrimination against LGBTQI persons as well. So this is an area rooted in the fundamental human rights principles of equal human dignity, non-discrimination, and the right to freedom from violence. But what would reform look like? Some of the things that are required are legislative and policy reform to ensure equal legal protection for all. And this is including as it relates to gender-based violence. So this is ensuring that forms of gender-based violence are prohibited and criminalised, but it's also ensuring that there are actually legal pathways for women and girls or victims of gender-based violence to pursue. And part of this involves training justice professionals on non-discrimination, on gender-based violence itself, so that they can understand what gender-based violence is and not minimise this. Part of the problem that we have globally is that the gender norms that operate so powerfully in each of our cultures speak about differences between men and women, but differences in behaviour. And some of these, in fact, can be part of romantic narratives. You know, it's a sign of strength, for example, if a man is leading the family. And, you know, there can be a misrecognition sometimes by criminal justice practitioners about what indeed is interpersonal violence and what is part of what we all understand to be broader gender norms. So training is required on these things so that when violence does ensue, and this is whether it is physical violence, sexual violence, psychological violence, emotional violence, spiritual violence, there are so many forms of gender-based violence, but so that they are not misrecognised or minimised. Training is very, very important. But so too is training on gender-sensitive law, ensuring that the law is comprehensive, that it is not exclusionary and discriminatory in and of itself, and policy and practice as well. And we think, for example, about policy and practice regarding, you know, the collection of forensic evidence. What is actually seen to be valid evidence? Who is seen to be a valid witness? And what kinds of evidence can be heard in court? For example, if sexual history evidence is heard in rape trials, this can have an incredibly traumatising effect on the victim, for example. So looking at the laws, policies and procedures around this to ensure that there's not that secondary traumatisation through justice processes, and indeed that justice is served. And part of this involves redressing the implicit and explicit bias that perpetuates discriminatory and harmful outcomes within the criminal justice system and within society more broadly. So I think that there's a very important need for us to understand that the oversights and patterns of discrimination within the criminal justice system on gender grounds are linked to patterns of discrimination in society more broadly. So it's very important that we do work on both of those fronts. I'll speak more as I go on about the criminal justice system and its role in society more broadly, because I think that it's a big mistake if we think about it as a discrete system that has nothing to do with the rest of society. But I wanted to very quickly just touch on this as a part of the rule of law. You know, the rule of law is a principle of governance in which all persons, institutions, entities, public and private, including the state itself, are accountable to laws that are publicly promulgated. These laws are equally enforced, independently adjudicated, and consistent with international human rights norms and standards. So I think that what we can sometimes see is that where the criminal justice system is not operating effectively, we might see that there are incursions into each of the principles, even within that very first sentence of the rule of law. So, for example, if the law does not apply to all persons, if the law is not equally upheld, if all are not equal before the law, if there is corruption within institutions, for example, and if the laws are not publicly promulgated, and there are no pathways, for example, for victims to seek justice via those laws, then what happens is I think that we see a weakening of the rule of law. The rule of law only works if these principles are upheld and if all of us as members of the community submit to the rule of law. We all agree that without the rule of law, we would end up in chaos. And so we are all actively upholding the rule of law all the time. And I think that this is why we have this concept in international law, and it's why we are doing work, in fact, to promote the rule of law. And I think that the COVID pandemic is a reminder to us that the rule of law is always a work in progress. So this is, we can talk about global north, we can talk about global south, we can talk about, the stages of development for particular states, but we need to recognize that in every country, the rule of law is always a work in progress. It is always about maintaining the faith, maintaining the trust of the community in the institutions that are put in place to serve the community. Justice institutions should serve the community. So they need to understand the community, they need to reflect the values of the community, and they need to uphold the rights of community members. And in this regard, community members then will uphold the law, because we know that there is this transactional justice system that we have mutually subscribed to. But of course, COVID has been very tricky, I think, for many countries around the world, globally. This has challenged the rule of law as states have grappled with how it is that they can ensure public health outcomes to the best of their ability in a very challenging time. And of course, law enforcement and criminal justice is a part of this. And so states have been asking community members to trust them a little bit more in many ways. When a lockdown is imposed and we all say, okay, I'll stay at home because the state has asked me to do this, this is now part of our regulatory environment, then we are placing also our trust in the state that there will not be an overreach. So we will not be, for example, over-policed if we need to leave the house to buy groceries, or for example, if a woman needs to leave the house because she is subjected to violence. We need to be able to trust that this is a mutual relationship of kind of trust and service. So I think that I just wanted to touch on that idea of the rule of law as always being a work in progress. So then when it comes to this question about human rights-based criminal justice reform and where it is that we can conduct this work in the world, there is the need for this work all over the world, all of the time. Because I think that it's also a changing landscape. We need to be thinking about the ways, for example, that new technologies have changed the face of crime and also changed the way that we conduct justice processes. We now have remote court hearings, for example. Are there ways in which human rights can be better upheld in these processes of remote court hearings, or are there ways also in which human rights could potentially be violated? So of course there's work all the time for international organizations like the United Nations to be working with member states to ensure that these criminal justice processes are in line with international law. And I wanted also to set this within the context of the Sustainable Development Agenda, in which, of course, security, the rule of law, and development are interconnected and mutually supportive. We don't have one of these things without the other. We need to be pursuing all things at all times. And it's not just SDG 5, 11, and 16 that are important. They're just the three that I have on the slide. But SDG 5 to eliminate violence against women and girls, 11 to create safe, resilient and sustainable cities, and 16 to promote peace, justice and strong institutions. And I think that it's clear, of course, that SDG 2, ending hunger, SDG 10, reducing inequalities, these are all part and parcel of this same project. And so I think that that's why having the Sustainable Development Agenda as a framework for our thinking can in fact be very useful, so that we don't conduct a piecemeal approach. We don't think, okay, this is a gender issue, this is a gender, we're looking at a crime or a system that should respond well to gender-based violence. So, okay, good, I know, we're looking at SDG 5. We're not just looking at SDG 5, we're looking at all the SDGs in conjunction, creating safe, resilient and sustainable cities. In some cities in the world, women and girls cannot move freely around the city at all hours because of the risk of gender-based violence, for example. So SDG 10 comes into play as well, reducing inequalities, for example. Okay, so I wanted to show you once more our standards and norms slide on crime prevention and criminal justice as the framework for our work. And the reason that I wanted to do this is because you can see at the bottom here that I've said that UNODC has developed a large range of tools to support member states in implementing these standards and norms. So we have not drafted the standards and norms. We support member states. We are essentially the secretariat as member states draft the standards and norms. And what we draft at UNODC are a range of practical guides, checklists and tools that can be used when working with member states, or member states can use these on their own to help provide them with the practical side of how it is that they can bring their systems into closer alignment with the standards and norms themselves. So, for example, I have policing and gender there, but of course we do have tools on all of the thematic areas that I mentioned earlier. So you might think about, for example, violence against children or crime prevention, restorative justice, we have those as well. But there was only so much that would fit on this slide. So I have thought to put there policing. So we have a handbook, for example, on police accountability, oversight and integrity. And this is really an important set of guidelines, but also practical measures that can be implemented in support of closer alignment to the international legal framework. So, for example, at the moment I am working in Kazakhstan quite a lot on a project in support of police reform there. And many of the principles, for example, in this handbook that UNODC has produced form the basis of some of the capacity building work that we are undertaking there. There's also a UNODC resource book on the use of force and firearms in law enforcement, and a handbook and training curriculum on police responses to violence. And if we come back to the issue of gender, there are many more tools on our website. For any of these topics, there are many more tools on our website. But there's a toolkit on gender-responsive non-custodial measures, so ways in which women might be kept out of the criminal justice system in certain circumstances. Also, what are the rights and needs, and what are the practical things that can be implemented to support women who are in a custodial environment. And one that I thought could be particularly interesting for you if there are, for example, prosecutors taking part in the call and also legal scholars, the UNODC handbook on for the judiciary on effective criminal justice responses to gender-based violence against women and girls. And this is quite a new publication. So if you go to the UNODC website, you can access all of the tools, including the ones that I have put here. So in our work, we are guided by the 8 principles that the United Nations Secretary General has put together in the UN approach to rule of law assistance. So essentially, this is the kind of work that we are engaged in, rule of law assistance. And I wanted to just touch on these principles because I think that they can be a bit of a touchstone for our discussion today. I have already, I think, clarified that all of the work that we do is based on the international norms and standards and, of course, on the broader international legal framework. But it's important also for us to take account of the political context. I mean, points 2 to 8 are essentially really all about taking into consideration the context, so ensuring that it's not something that is just coming from, for example, UNODC headquarters without any understanding about what's going to work on the ground, but also ensuring that there is national ownership, so ensuring that the stakeholders that we are working with in a member state are able to and willing to, and they see the value of taking the advice and trainings and so on that we deliver, taking those and then taking them forward. So, for example, if we work with a country for 2 years, 3 years, what happens when we leave? Is there the capacity built within the systems among national authorities to continue with that work, to deepen that work, so that the capacity is there when additional challenges arise. For example, a challenge like COVID that we didn't see coming, is there the capacity for the correct responses to be put in place? And 7 and 8, ensuring a coherent and comprehensive strategic approach and engaging in effective coordination and partnerships. These are really important for us to keep our eye on the context within which criminal justice sits. And this is where I had said before I'd like to talk a little bit about criminal justice in terms of society more broadly, and that's what I'll move towards now. Because meaningful criminal justice reform requires interaction with a wide variety of institutions and actors. So this is just a snapshot of who is involved within the largely formal criminal justice institutional sphere. So the first tile there, criminal justice management, it's extremely important that there is buy-in from the highest levels when we propose human rights-based criminal justice reform. It can't be, for example, that we are just working with one police precinct and we've only got sort of frontline officers that are committed to the ideas that we are sharing with them. Because there does need to be much broader support for this if there's going to be that organisational change and that policy change that's required for there to be meaningful human rights-based criminal justice reform. But we also work a lot with courts, prosecution, detention and prisons, work with lawyers to ensure that the skills are there that are needed, the skills and the knowledge, and also with defence. So we're working with prosecution and defence, of course. But there are other institutions and actors that we sometimes need to work with. For example, in some situations, and particularly in post-conflict or transitional state settings, we might need to engage with the military. There are also intelligence services that may be internal to police systems or external. It's important that we also keep an eye on understanding what alternative dispute resolution mechanisms there might be. So, for example, there could be opportunities to divert individuals from the criminal justice system, and that for there to be, for example, non-custodial measures. And of course, there's customary justice in some countries that can play an important role. And this is something that we also need to keep in mind, and also ensure that this is that these are processes through which human rights are also upheld. But then I want to zoom out. So now you can see that our criminal justice system sits within a much broader field, a social, cultural, political field. These large systems that we draw on, if we look at the top 3 green circles, social services, health, education, these systems shape the lives of members of the community. If there is no access to health care, access to education, if there is no social protection, social services available, then the fact is that we will actually see more people funneled into the criminal justice system because of hardship, because of survival crime, because of things that are conducted that are criminalised that may just be acts of survival. And so what we see, the 3 at the bottom, family supports, rehabilitation services, housing services, these are essentially facets of the top 3 there. But these are practical supports that can be provided to individuals that are in contact with criminal justice systems. Victims, witnesses, accused persons, prisoners, prisoners that have just been released. All of these services are super important. So essentially what we really need to see, if we want to see a holistic approach to upholding the rights of individuals that are in contact with justice systems, is that we really need to see this as a web of partnerships, very powerfully functional partnerships. And unfortunately, of course, we know that these kind of multi-sectoral coordination efforts are really tricky. And this is partly because, you know, I know in academia we always talk about working in silos. You know, I'm a social scientist, so I'm working in my social scientist silo. I mean, even social sciences is probably a pretty big silo, right? But, you know, criminology is a silo, and we don't necessarily work, for example, with sociologists. And this This, of course, isn't the case, and indeed we know that this interdisciplinary research, when it happens, it can be incredibly powerful. But we have our own disciplinary bias that prevents us from coming out of the silo. And I think this can, in fact, be something that makes this multi-sectoral partnership work challenging as well. So is health talking the same language as education? Can we understand the priorities of social protection? What are the referral mechanisms like between these institutions? And also, how the privacy rights of individuals being upheld if they're being referred between these institutions. If it's not done well, we can see lots of gaps that people can fall through. And these can be formally created gaps. So there might be legislative or policy criteria that exclude certain people, for example, from social services. There might be very narrow legal or policy criteria as to who is eligible for those services. Or it could indeed, and so there would be work to reform those to ensure that that social protection is there so that individuals don't come into conflict with the law, for example, or that they aren't disproportionately at risk of being victimised because of their socioeconomic status, for example, or their employment status, and maybe underemployed or not employed at all. And we know that those things are a context of risk for crime and for social for challenges within society. They are not conducive to social inclusion, social cohesion, and crime prevention. So we think about it in terms of the developmental crime model, where we have risk factors and protective factors. Bolstering the protective factors, all of these green things are to bolster the protective factors to prevent individuals from coming into contact with criminal justice systems. So partnerships work is a really important part of that. Okay, so in our work, we basically follow a 4-stage process. And the first is to conduct a situation analysis. So I'm going to talk about this first stage for a little while, and then if we have time I would like to talk about the second. But essentially we conduct a situation analysis so that we can understand exactly where the entry points might be. So what is the most important, what are the priority areas of work for us to be doing to implement human rights-based criminal justice reform? And of course for that, as I'd said before, we need the buy-in. So we can't just have UNODC ideas about what can and should be done. We really need to work with our national counterparts hand in hand to understand what are the priorities for them. And so once we have heard their priorities, we are able to work in partnership to build a menu of work, which is the stage 2, the program planning. But it's important that at each of these stages, analysing the situation and starting to formulate a plan and to do the programming work, implementing that, so on the ground, assisting, delivering training or providing legal advisory services, and also in the monitoring and evaluation phases, it's very important that a human rights-based approach is implemented at each stage. And so you might say, well, monitoring and evaluation, how is it that you would need to uphold human rights through this process? We could have an hour-long or day-long lecture just on that topic alone, but we can think, for example, about inclusive practices in evaluation, ensuring that the voices of all beneficiaries are heard, the voices of the most vulnerable and the marginalised, those that very often are not heard. But also there are safety considerations when we are conducting monitoring and evaluation exercises as well, ensuring that by coming forward and sharing their voices, there is no stigma, there is no backlash, for example, within the community. So there's many, many considerations. At each of these stages, we need to have human rights as our foremost consideration. And indeed, this means that the work is not fast. The work is slow, but also change, reform is slow. Reform should be slow because it should be very considered. So if we stay on that first stage of conducting the assessment, I just wanted to highlight that UNODC has a criminal justice assessment toolkit. So it looks like, the way that I've pictured it there, it looks like it's just one book. And indeed it does exist as a book, a very, very large book, because it's essentially a compilation of tools on all facets of justice and how it is that you can ask questions to help assess the state of that facet of justice, let's say police, and the sorts of things that you might consider to put in place to support human rights-based criminal justice reform. So I just wanted to draw your attention to that. And of course, that's available on the UNODC website. But you will see it as a series of links. You'll find the Criminal Justice Assessment Toolkit, and then you can link to whichever aspect of it interests you. And when we conduct an assessment, there are various phases. Of course, before we do anything, we do a lot of desk research. We analyse legislation, we map the justice system and its components, including those informal components that I spoke about. We might undertake a country visit to meet with national authorities. And again, this is entirely geared at hearing their priorities, hearing the views of national authorities. They are the ones that are working in the system, and it isn't their system after all, but we really want to hear ways in which that they understand we could potentially help to strengthen their approach. And then there's an analytical phase where we undertake a multidisciplinary analysis. So I'd spoken before about my faith in multidisciplinary analyses. And in this, of course, human rights-based approach and focusing, remember, back on the Secretary General's 8 principles, one of which is national ownership. It's extremely important that national voices are involved in this process, that it's not something that UNODC headquarters is doing on its own, but that there's really this buy-in and support and expertise. So there's a great recognition of the expertise in the country as well. And you can see the purposes there, to understand the infrastructure and the human capacity, how the system's working in practice, as opposed, for example, to how it's working in theory. I think it's always important to, it's a little bit like law in practice and law in the books. I think we always need to be mindful of this potential gap in any country that we might be looking at. The level of communication and interaction among the various components of the system. So remember my vision for a joined up network of partnerships. And then to identify areas in which we might provide support. But you can see there as well at the bottom the importance of consultation. So again, this must be a process where the marginalised voices are also heard and meaningfully inform any responses that are taken forward. I thought perhaps to share a couple of examples with you about projects that UNODC has undertaken. So the pandemic, for example, has put a spotlight on the absence of data in many countries to inform evidence-based reform and action regarding legal aid, access to legal aid. And so in response to this gap, UNODC is in the final stages of developing a comprehensive legal aid assessment tool. So this is another tool for us that will help build the evidence base on legal aid, including by capturing data on the role of criminal justice actors, police, ensuring access to legal aid at the earliest stage. So that is forthcoming. That should not be long, and that will be on our website. And essentially what it is a practical tool to assist in implementing the United Nations Principles and Guidelines on access to legal aid in criminal justice systems, which is also available on our website. Apologies for skipping quickly past those, but there's a time imperative. And I wanted to talk a little bit about the second stage, which is program planning, and to look at some of the key components of reform programming. So law reform, police reform, court reform, detention and prison, capacity development, so training, but also really sharing and fostering skills development through capacity development, not just providing information, legal empowerment, addressing the needs of vulnerable groups, and partly this is done working with customary and non-state justice systems, looking at the challenges of corruption and discrimination and violence that is within criminal justice institutions, but also between them. So that networked approach, we need to be looking at where are there any discriminatory barriers and obstacles between the joined up approach that we're talking about, and promoting a culture of lawfulness. So what I wanted to do was to talk about now addressing the needs of vulnerable groups. And if I have time, I'll talk about legal empowerment and promoting a culture of lawfulness, but very quickly it will be. So vulnerable groups. I just wanted to say before going into this that I use the term here vulnerable groups, but I'm deeply uncomfortable with this kind of language. I think that I much prefer the way that I have framed it on the slide there, which is persons made vulnerable due to discrimination, structural inequality, and structural violence. So if we look at the groups, this is just some of the groups that we would sometimes think about as being vulnerable. You know, we may need to put in place specific supports and safeguards for women, for children, including those accused of crimes, for the rural and urban poor, Indigenous, ethnic and religious minorities, migrants, refugees. You can read those on the slide. All of these groups and more. But I just want to stress that there's not an inherent vulnerability here. Women are not inherently vulnerable. Neither are children. Neither are, LGBTQI people. Inherent vulnerability contradicts our idea of the principle that we see in the Universal Declaration on Human Rights, that we are all born free and equal in dignity and rights. We are all free and equal. Some of us are discriminated against more than others. And so the intersectional forms of discrimination that some individuals and some groups face contribute to what we can see as being a very profound marginalization in society. So I think that's an important point about this vulnerability. And here I elaborate this by just reflecting on the concept of structural violence. So the systematic exclusion of certain groups from services and opportunities that are provided to others. And this can be social marginalization, political exclusion, economic exclusion and exploitation. Again, we could talk about that one for a day. But if we take that as our frame, it's then our job to understand the role of discrimination, structural disadvantage and structural violence so that we can apply a needs-based approach, but crucially a rights-based approach. It needs very much to be about upholding rights, as well as identifying needs and recognising intersectional forms of discrimination, disadvantage and violence. And so there are some questions that we can ask. So if we are wanting to assess how well the criminal justice system is catering to the needs and upholding the rights of persons that are made vulnerable due to structural violence and discrimination, then there are some questions that we can ask. And these include, are justice institutions operating in a way that is responsive to vulnerable groups? Are vulnerable groups represented among judges, prosecutors, defence attorneys, court personnel, police? And at all stages. Are court personnel educated and trained to recognise and accommodate the needs of vulnerable groups? Are police trained in this way? Are court proceedings, are police interviews conducted in a language that is familiar to vulnerable groups? Having an interpreter is not optional. Oh, sorry, I didn't mean to. And how do vulnerable groups perceive the justice system? And there are mechanisms, of course, for ensuring that these voices are heard. And I've made that point, I think, already. But victim surveys, for example, are a very important way of understanding what is happening in terms of vulnerable groups, their access to justice, and, for example, how they might perceive the criminal justice system. And now I can't move on. Okay, there we are. And then there are a range of things. Once we've asked these questions, there are a range of things, of course, that we can do to provide support for vulnerable groups. And all of the things on this slide, in fact, apply for human rights-based criminal justice reform more generally, but they are particularly important, I think, when it comes to supporting the needs of vulnerable groups. And I see there legal empowerment, which is the second last point that I'll move into in just a moment. But I did just want also to flag the international treaties and guidelines that address the rights of vulnerable and marginalised groups. And part of the reason that I've done this is that it's a comprehensive Look at how many there are on this slide. And I think, I can make these slides available, but I also know that the presentation is being recorded, so perhaps you can look at these in slower time. But this, of course, is the normative, the legal basis on which this support for vulnerable groups is based. And this is where we go to understand the rights of vulnerable groups as well, and to ensure that they are upheld at all stages of justice proceedings. And one of the ways in which, in fact, this can happen is through legal empowerment. And there are a number of features of legal empowerment, which include identifying the justice needs of the poor and the vulnerable groups, those that are marginalised, rather than always listening to the voices of the powerful. This involves strengthening the roles, capacities, and the inherent intrinsic kind of skills and power that the population can bring to their own justice needs. So providing practical information and legal know-how to members of the community, so in fact they know where to go to seek access to justice, for example. And this also involves, if you look at the last point there, drawing on lessons and experiences from other countries, rather than all the time looking to the global north for solutions. I think that this kind of exclusion of voices of lived experience can in fact be a major part of the problem. And so we have two quick examples of projects that UNODC has implemented that are essentially about legal empowerment and access to legal aid. The first is in Pakistan, an effort to reduce the number of under-trial prisoners. UNODC hired a team of 21 lawyers to enhance access to justice in the High Court, the Session and the District Courts in the Sindh region. And this project facilitated legal support for prisoners in need, including by lodging release requests with the court. Lawyers pursued cases until release or conviction, and the project exceeded targets because the majority of the cases resulted in release, more than 500. And I think that this is really, a project that we could have undertaken anywhere, because the challenge around access to quality legal aid for under-trial prisoners is really a challenge globally. So this is a really nice project that, it would be brilliant if we could replicate this in other places. A second example is strengthening the capacity of legal aid providers in Sierra Leone, Liberia and Senegal. And this was a joint project of UNODC and UN Women that sought to strengthen the capacities of legal aid providers on delivering tailored assistance to women and girls. And this was offenders, victims and victims suspected or charged with an offence related to their self-protection. And the project also delivered grants to civil society organisations to enable the continuity of legal aid services for women suspects, prisoners and victims. And there was also a research component to this project to understand the ways in which COVID-19 had intensified challenges in women's and girls' efforts to seek access to justice. My very last point is about promoting a culture of lawfulness. And one of the ways in which we can do this is through education, the most powerful weapon with which you can use, that you can use to change the world. And UNODC has a global program that we call the implementation of the Doha Declaration. And there are 4 pillars to this program. There's the Education for Justice pillar. There is a pillar on judicial integrity, and this one might be of interest to participants of this webinar, because there are a range of materials there on integrity across judicial systems, but also prosecutorial systems. And there's a very nice range of podcasts that accompany this work, and they are available on the UNODC website. If you were to type in UNODC and Doha program, you would find the Judicial Integrity Network. There's also work on youth crime prevention through sports, so promoting a culture of lawfulness by essentially bolstering those protective factors that I mentioned earlier, ensuring that there are opportunities for young people. There is skills building There are community cohesion initiatives through sports. This is a very important crime prevention approach. And there's also the prisoner rehabilitation component to this work. But it's the education that I wanted to focus on very quickly here. And the Education for Justice initiative operates at the primary, secondary and tertiary levels. So there are materials that are developed in conjunction with educators from around the world. So ensuring that the voices from around the world, the knowledge and the skills and the perspectives of educators from around the world inform this work. But what it means is that primary teachers, secondary teachers, but also tertiary educators can access these materials on our website for free, and they can use them to teach children about, very young children are taught about values of fairness and sharing and equity and respect and dignity. But by the time we reach the secondary education, the messages are more complex. And then, of course, at the tertiary level, which is the one that perhaps interests us most for this webinar, there are more than 115 university modules, so classes, essentially lectures that can be downloaded on all of these topics. There are 9 topics along the bottom there: ethics and integrity, corruption, crime prevention and criminal justice, organised crime, firearms, cybercrime, wildlife crime, counterterrorism, trafficking in persons and smuggling of migrants. And academics can access these modules to be strengthening their own teaching on some of these topics. And this is not because there's not already incredible capacity in universities all around the world, but it's simply a way of ensuring that, for example, in a sociology class, which might not teach specifically on access to justice for victims, for example, we have a very nice module in the Crime Prevention and Criminal Justice series on access to justice for victims. So a sociologist that teaches very well on a range of other topics might be able to pick up some ideas from that particular module and embed them within his or her class. There are no rules about how these are used. They are just freely available on the internet. They can be used by higher education students as well, PhD students that are looking for perhaps lists of reading on some of these topics. So the crime prevention and criminal justice is very relevant to our topic today. And within that series of modules, we have a module on violence against women, gender in the criminal justice system, restorative justice, legal aid, prison reform, alternatives to imprisonment, judicial integrity and the role of prosecutors, police reform. There are a range. There are 14 within each of the series of 9. So I did race just a little through some of those final slides, but there were a few things that I had wanted to share, and I hope that some of that is interesting and useful to you. And thank you very much. I will be happy to take questions if there are any. Thank you.
Thank you so much, Dr. Wendy. It was really a very enlightening session. So I have got certain questions for you, and I hope that it's like, I know that we are holding you back, but our viewers and also our participants would like to know it from you. The first question is obviously from me. You know that as as a cyber victimologist, I have been working on this cybercrime area. So you know, as an officer in the UNODC and also as a criminologist, that the deep dark net has evolved, and during the pandemic time, we do get to see that there are increased victimization of women, especially women and girls, in the deep dark net. So what is your view in this regard?
Thank you very much for this question. This is and I am aware of your work in this area, and I really thank you very much for your dedication to this topic, because I think that we are at my personal view. So this is not really a UNODC response. This is my personal view, as an academic, as a woman, and also in terms of what I see in terms of crime around the world. We are in a situation where our technology has developed so quickly that we have not had the opportunity to put in place either the law or the moral frameworks that we need so that we can cope well with the opportunities and the challenges that this technology brings. So, when we see, for example, image-based abuse, the sharing, the non-consensual sharing of intimate images, which occurs around the world at a speed that we cannot fathom, and we do not have the laws to cope with this.
Absolutely.
And it's not just a question of implementing law either, because we then need to do all the systems work around that. We need our prosecutors to be educated. We need our police to be educated, judges to be educated. And this is a massively complex undertaking. And I actually, I think that you've sort of really touched on what I think is one of the biggest challenges of our time when it comes to thinking about cybercrime. Because I know that, for example, we also place a lot of emphasis on other forms of crime that are perpetrated using technology. So economic crimes, we seem to be better at legislating against these and prosecuting these than we are at these interpersonal crimes. And I think that so we've got already this crisis with gender-based violence that I mentioned, and now we've got the digital component of that crisis mapped on top of it. And it's really a very deep set of challenges that we have, and there does need to be this fundamental kind of commitment, I think, globally, that these crimes are unacceptable, and that we do need to put in place the safeguards, but then also the laws and all of the training that is required so that there is meaningful access to justice for victims of these types of crimes.
Yes. So the second question is, any instance showing criminal justice is not developed enough in spite of various dialogues for the same. So has UNODC has received any instance of such cases, or you, in your personal opinion, you feel that there are lacuna in the criminal justice system in spite of so many dialogues that are happening? Any specific country that you feel that is lagging behind, or if in such case, if any country is actually having such kinds of things, what should we, the academicians in the legal fraternity, we should work upon?
This is a good question. I mean, I think that one of the things that I would say as a framework is that it's a moving feast. We're not looking at something that is static. So just as I said in my remarks that, the rule of law is a work in progress, so too is human rights-based criminal justice reform. And we need, I provided countries that we're working in there, Sierra Leone, Liberia, Pakistan, but we also need to be looking at systems in Australia, in Canada, in Norway. Human rights-based criminal justice reform is an imperative globally. So I think that we actually can make a mistake if we look to one system or to one country and we say, this is how it should be done. But really, rather, what we can do is look at systems and say, okay, there's one small component there that's working very well. Or there's one story about reform over here. So, for example, the story that I shared about Pakistan, there was a problem, there was an intervention, and in that case, it was successful, and nearly 500 under trial prisoners reclaimed their liberty and are able to go on and support their families and live their lives. I mean, there are ways in which we do see success in snippets, and I think part of our work at UNODC is pulling these together so that we have a compendium of what has worked in what context. So then when we go to another context, we can sit down and have those consultations with national authorities and ask what their priorities are. And very often they do ask what has worked well elsewhere. And so we are able to say, here's an example of something that has worked elsewhere. But it might not work in exactly this form here. Maybe we need to have a conversation about how we could tailor this to the local or national context. So, it's ongoing work. When I leave this job, when I retire, which is quite a long time from now, there will be someone else that will need to do it. I think that, this is not something that we're going to have done in 5 years, in 10 years. This is a work in progress.
Yes, absolutely. The next question that I have is during the pandemic time, we have seen that many women, especially in the Asian, including South Asian countries, many women were basically locked inside their homes and they had to stay in abusive relationships. So as you said that, access to justice for women and girls, and the first slide that you showed, that many phone calls were basically got like, many phone services got jammed, especially during this lockdown period. What's your understanding? What's your opinion in this regard, where women had to stay back, or in future, because lockdown is continuing in many countries? So when women have to be there in a very abusive relationship, they cannot come out. So what's your opinion? How we, from the legal fraternity, especially legal academia fraternity, how can we help such kinds of situations or such kinds of women?
This is another excellent question, and you really are touching on the topics I think that are our greatest contemporary challenges. It's very difficult to think about the depth of suffering for women, and I think we also need to think about children caught in these circumstances as well. As schools are closed in many parts of the world, children are also in these abusive homes, and we do know that where children, even if children are not subjected to the physical violence themselves, witnessing the violence is itself a form of violence against children. So there are a range of human rights violations there, and a range of acute justice needs that we absolutely have to acknowledge. And I do think that as the pandemic continues and lockdowns continue, there are no easy solutions for this. I mean, of course, there has been a lot of work around the world in using digital solutions. So sometimes, women can make reports online to police, or they can access legal advice online. There are code words that have been introduced in some countries. So if a woman goes to the supermarket to buy groceries, she can make a code word to the cashier, and they will know that they need to make a police report about violence. But these are incomplete solutions. These are efforts to deal with a very chronic situation. They are incomplete solutions. For example, the digital solution brings its own risks. So, for example, if a woman is trapped in an abusive home, she does not necessarily have access to a nice spare bedroom where she can close the door, have all the privacy in the world to make a complaint online to the police and to receive advice, or to engage with, the counsellor that she might be seeing at a women's shelter, for example. These sorts of services really are not lending themselves very well to online delivery. And there's also, of course, a digital divide. There isn't a computer in every home.
Yes.
Not everybody has a smartphone in their hand. And then on the other side as well, we don't necessarily have the police resources or the domestic violence crisis shelter resources to be answering all of these calls and providing these interventions. One thing that I would say that I think is important is that when there is a lockdown imposed, I think that there needs to be a balancing of, there needs to be calibration of the response. We have a public health crisis, a shared public health crisis globally. I would never want to diminish the significance of this. We have all been at risk, and we all continue to be at risk. And yes, it is important that social distancing is put in place to prevent additional infections. And essentially this prevents additional deaths. But at the same time, when we do know that we have this chronic situation of violence in the home all over the world, one of the things that I think that is beneficial is that when the guidance that comes from the state, the decree that comes from the state essentially about the lockdown, is that you can leave your home for only 1, 2, 3, 5 reasons. One of those reasons must be if you are unsafe. For your own safety, or the safety of your children, you are permitted to leave the home. And I really think that this does need to be made very clear at the time that the lockdown measures are promulgated, so that women and children have absolutely no fear in leaving the home. All the fear of the violence that they're experiencing, of course, is not something they can shed, but there needs not be additional fear that they would face repercussions from the state for having left the home. And then, of course, what there needs to be is training and awareness raising with the police and any, traffic officers or public transport officers that might be working to help regulate the lockdown and to help control curfews, so that they are all aware that if a woman and her children or any person is fleeing the situation of violence, then they are entitled to access justice. There is absolutely no recourse to then provide them with a fine for having left the home. So it's not a solution. If I had the solution to this, I can assure you I would be promoting it and doing my very best to implement it, because, like you, I'm really concerned about the levels of suffering at the moment.
Thank you so much. Thank you so much. I invite now Professor Dr. Akil Syed, sir. Sir.
Yes, ma'am. Actually, I do have lots of questions. Rather, I made the list of the questions. So, and we do not have enough time to have all this discussion. So, I'll take a leave from Professor Wendy to send you the mail, ma'am. And we will remain in touch, because you talk about so many activities, and we are also involved. We have completed 2 research projects. One is about police accountability in the state of Gujarat, and the other we have made a proposal before the Department of Justice that is on the judicial competency. So to reduce the judicial backlog. So these are the 2 areas in which we are already working. So now if we could get an assistance or we could get support from UNODC, so I'm sure we would be able to perform much better. And you mentioned about assessment toolkits also. So my question was whether we can use this toolkit for our research at local level, identifying the parameters.
I'm very sorry, but I was having difficulty hearing the last. I heard all of your remarks, but I missed the question.
No, it's okay.
Let me explain.
We'll remain in touch through the mail, because it's already, we are running against the time.
Yes.
For 1 hour session, we have already taken on 17 minutes more. So we conclude here, Professor Devarti. Then we will remain in touch through the email. Thank you, ma'am. Thank you very much for being with us and sparing your valuable time. It's not the conclusion of the program, rather beginning of our journey together. Thank you. Once again, thank you very much. Thank you.
Thank you so much, Dr. Wendy O'Brien. Thank you for giving us your time and also your expert understanding on the issue of human rights-based criminal justice reform. Thank you again, and we wish to have you again in our other webinars and also collaboration. Thank you.
Thank you very much. Thank you.